The Honourable David Parker.
Thank you, Mr Speaker. Can I begin my contribution by pointing out that the conduct of this bill shows the importance of our select committee processes, because the bill as this went to select committee was a poor piece of legislation and I think reflects well on the chair of the committee, Melissa Lee, the minister who was responsible to the concerns that have been raised by the select committee, that the bill has been sorted out largely and is in a form which the Labor Party can support now at this third reading. Sir, I would contrast that with some other bills that I've been involved with, notably the Resource Management Act, which is an absolutely atrocious piece of legislation that is obvious to everyone on the select committee needs significant modification, and yet for 5 months the select committee has made no progress on that legislation while things have gone on in the background. But the select committee's skills haven't been brought to bear, and unlike the process that's being used in the this patents bill, the dire state of the Resource Management Legislation Amendment Bill or the Resource Legislation Amendment Bill doesn't benefit from the same input from members of the Select Committee, and therefore we're left more in the hands of the Minister and the officials, notwithstanding that it's obvious from submissions that there are fundamental problems with the bill. So for those reasons, I actually want to compliment Melissa Lee and the Honourable Paul Goldsmith for the way in which they've actually been willing to listen to the issues that came up through Select Committee, to give some of the members of their Select Committee, to place trust in them, to actually bring forward the suggestions that were needed to cure the fundamental problems in the bill. Sir, I do think that when you get a bill that's as fundamentally wrong as this one was, both in terms of the cost-benefit analysis that accompanied it to the House and the substantive provisions in the bill, it is actually incumbent upon us as parliamentarians to actually say to the officials who were behind this, really not good enough. It was a pretty poor effort, and it was going to increase the complexity of and the cost for New Zealand patent attorneys in a way that wasn't going to be reciprocated by their Australian comparators, and wasn't going to save costs through a single examination through the single patent application process and the single patent examination processes that were proposed. That wasn't going to work because the underlying law for patents in each country was still going to be different, and therefore there would have to be examinations for many patents as to whether those differences in the underlying law in Australia and the underlying law in New Zealand meant that something should either be approved or not approved in Australia, or approved or not approved in New Zealand. So the idea that you could have some single patent examination process that was somehow going to save significant cost was wrong. Sir, that said, the bill as amended does have the support of the Labor Party, and we thank the government for their willingness to be accommodating of the concerns that were noted by the Labor Party as well as submitters on this occasion. Sir, patent law is very important. It is important that as a society we encourage innovation. Those who are innovating and investing in innovation cannot afford to do so if their innovation can be stolen and replicated by someone else after they have spent that money and investment on that new knowledge or that new invention. That is the philosophical basis for patents, sir. It is that as a society we are better off if we encourage innovation, because we benefit from the new discoveries that are made and the new inventions that flow from that innovation. The return for the patent holder is that for a period following their discovery, they have a monopoly right to the commercial benefits that arise from their discovery. That should not go on forever. monopolies do as monopolies are reputed to do, and a monopoly faces much less constraint on their ability to charge or overcharge than if they face competition. And it's for that reason that there are rules surrounding patents that are quite strict, both as to the length of the patent and to what is patentable. There has to be a degree of novelty about the invention that is not obvious, that adds to the sum of knowledge that would have occurred but for the discovery that's published through the patent. If it wasn't for the patent protection, there would be an incentive upon people to keep things as secret forever in a way to protect their invention. That would mean that that invention would not, during the period it's secret, be as widely utilised, and therefore the benefit to humanity of that invention would be less. The quid pro quo is that if you make public and then have controlled use of that patented invention, because once the patent pops out of its black period during the application phase, the patent itself, which describes the invention, is public, so the world learns of it, and if it's a great thing, people can beat their way to the path, knock on the door of the inventor and try and get rights to commercial use of it, and through that mechanism can bring that innovation to the world, and the inventor gets a monetary reward for that during the period of their monopoly control. At the end of the period, it drops off patent, and the world is free to use that innovation, subject to there not being other patents that are still current that could prevent their utilisation of what is of the patented inventions. So that's the balance that we try to get right. We want to encourage innovation, we want to give a reward to the innovator, but we don't want to extend their monopoly rights for too long, because that goes the other way and suppresses the use of that invention to the detriment of humanity. So, sir, those are the principles that underlie patent law. There are some differences between New Zealand and Australia in patent law that mean that the idea that we could have had a single examination process was impractical, and I hope that the Minister is having a look at what went wrong in the background, both in respect of the cost-benefit analysis and the substantive provisions as they were in the original bill.